Published under the authority of the House. Are there any select committee reports? There are none. Are there any bills for introduction? No bills for introduction. The House then comes to questions for oral answer. And the first question stands in the name of the Leader of the Opposition.
Thank you, Mr. Speaker. My question is to the Prime Minister. Does he have confidence in all his ministers?
The Right Honourable Prime Minister.
Speaker, yes.
The Leader of the Opposition.
Speaker, how can the Prime Minister have confidence in the Minister of Land Information and the Associate Minister of Finance, given that the decision to sell Crayford Farms to Shanghai Pengjing was just being set aside in the High Court?
The Right Honourable Prime Minister.
Well, Mr. Speaker, it's important to understand the role of ministers, which is to follow the law and the interpretation of the law. All I can say at this point is that the interpretation given to the Overseas Investment Office by their own internal counsel of the way that they would interpret the law is clearly different to the way the judge sees things.
The Leader of the Opposition.
Supplementary. Given the Court's decision today, does he have confidence in his own judgment, given that he said, quote, the law would not have allowed us to reverse the decision made by the Overseas Investment Office?
The Right Honourable Prime Minister.
Absolutely, because the law states, as was the recommendation from the Overseas Investment Office, that Sections 16 and 18 of the law need to be complied with. It was the belief of the Overseas Investment Office that Sections 16 and 18 were complied with, and indeed they may still be complied with. What will now happen is that the Overseas Investment Office will need to go back and have a look at the application and decide whether it meets the criteria as prescribed by the judgment today from the judge. That may still stand.
The Right Honourable Winston Peters.
Could I ask the Minister how he could possibly say that the two ministers concerned in fact interpreted the law correctly when... No, he never was. He's your mate. And a crook one at that.
Order. The member will resume his seat. I'm on my feet and the member will cease interjecting. Now, it's not uncommon for members to interject, and it was a very mild interjection, but members asking questions shouldn't have to react like that. This is question time. The questions being directed to the Prime Minister are important. Let's hear the supplementary question.
Very important,
Mr.
Speaker.
Peters.
How can he say that these two ministers interpreted the law correctly when a court of law with a legal background says they have not? And that's the reason why it's been set aside, or does he know more than the judge at court as well?
The Right Honourable Prime Minister.
Mr. Speaker, well, it's important to understand the process here, which is for... Actually, since 2005, with ministers from Labour, they have relied on the Overseas Investment Office's interpretation of the law and the way it's been prescribed. Now, it's not unusual for judges to have a different view from internal counsel. In this particular case, they've done that. But I will add that those ministers have relied for a very long time on the same view from the Overseas Investment Office.
Before I call the Leader of the Opposition, this obviously is an issue of considerable public interest. I want to hear the Prime Minister's answers, even if the Labour front bench doesn't want to hear them. I can't imagine what the point of order might be.
Well, wait to hear it, sir.
I'm listening.
Thank you. Mr. Speaker, the Prime Minister made a reference to me alleging that my conduct had been illegal or...
Order.
In some way.
I've heard sufficient. The member will resume his seat. The member will resume his seat right now. The interjections from the Labour front bench started long before that. The matter is serious. I think they should show courtesy to their own leader, because I want to hear the answers to his questions. David Shearer.
Thank you, Mr. Speaker. How can he express confidence in his ministers when the judge ruled in paragraph 44 that the ministers, quote, misdirected themselves in law?
The Right Honourable Prime Minister.
Because that is, I haven't read the full judgment, but that will be on the basis of the fact that they have relied on the interpretation of the law as they understood it, as ministers in a Labour government did as well. It's the same advice and it's the same opinion that's applied ever since the Act has been there since 2005. It is not unusual in New Zealand for the judges to have a different interpretation from a body like the Overseas Investment Office. So all of the decisions made by Labour in the past on recommendations by the Overseas Investment Office relied on the same legal interpretation from the Overseas Investment Office.
Dr. Russell Norman.
Thank you, Mr. Speaker. does the Prime Minister now accept that his and his government's assertions that there was no other decision possible now no longer stands up to scrutiny, and it may be entirely possible that another decision was possible?
The Right Honourable Prime Minister.
Mr. Speaker, no, because if one looks at the advice from the Overseas Investment Office, they make it quite clear that ministers need to follow the law and interpret whether Section 16 or 18 of the Act have been followed. If they have been followed, ministers would have to put up a reason why they believe, if they're having a counter view, those conditions weren't met. Ministers had no reason to believe those conditions hadn't been met.
The Leader of the Opposition.
Thank you, Mr. Speaker. How can he express confidence in these ministers when the judge ruled in paragraph 38 that the ministers ignored, quote, clear evidence that the benefit will accrue anyway should the land remain in New Zealand ownership?
That's right. The Right Honourable Prime Minister.
Because, Mr. Speaker, the Overseas Investment Office applied a test in relation to benefits which said, were there benefits? The judge is now saying there's a new interpretation about the counterfactual of additional benefits. That's not the way the law was interpreted for all of the advice provided to David Parker when he was the Minister in the gun.
The Right Honourable Winston Peters.
How did the Prime Minister arrive at the view that his two ministers had no discretion at all to exercise and were required to merely endorse the view of the Overseas Investment Office?
The Right Honourable Prime Minister.
Because it may come as a novelty, but they need to follow the law. And the law states that Sections 16 and 18, if they want to have a different opinion, they need to give that opinion.
I apologise to the Prime Minister. The Right Honourable Winston Peters asked a perfectly reasonable question, and I don't know whether he could hear the answer, but I struggled to hear the answer again because the interjection's on my left. That's not reasonable. The Right Honourable Prime Minister, has he finished his answer?
Mr. Speaker, the Overseas Investment Office made it quite clear in the correspondence to the ministers that they are required to follow Sections 16 and 18 of the law. They are quite entitled to change their opinion from the opinion offered by the Overseas Investment Office, but they need to give reasons why. And in the opinion of the law as it was interpreted, there were no reasons.
The Leader of the Opposition.
Thank you, Mr. Speaker. How can he express confidence in these ministers when the judge ruled in paragraph 57 that the error was, quote, not a mere technicality and that the economic benefits caused by the overseas investment were materially overstated?
The Right Honourable Prime Minister.
Mr. Speaker, that is the opinion of the judge that will have to go back. Just before everyone gets a little bit excited here, the process will be that the Overseas Investment Office will have to go back and reconsider the application in light of the new ruling by the judge, and it's eminently possible that the Overseas Investment Office will come up with exactly the same recommendations and ministers will continue to accept it.
Dr. Russell Norman.
Thank you, Mr. Speaker. Does he accept that the law as it exists today, now following this judgment, means that the government has to consider New Zealand buyers of New Zealand land and the benefits that they will bring, not just the benefits that come from overseas buyers, or to put it in colloquial language, that New Zealanders should get a fair go?
The Right Honourable Prime Minister.
Mr. Speaker, I'm not in a position to offer advice on that because I haven't had advice from Crown Law, although it's my expectation we'll get advice from both Crown Law and the Overseas Investment Office this afternoon. But what it is fair to, I think, characterise in these high-level terms is that the previous test, as understood and applied by the Overseas Investment Office right from 2005 when Labor wrote the law and were the government, were there benefits. The judge is now saying a counterfactual has to be considered whether there are greater benefits. That's a different test.
The Leader of the Opposition.
Thank you, Mr. Speaker. In light of today's High Court decision, does he now accept that blaming the China Free Trade Agreement and the fact that ministers had no discretion were plain and simply wrong?
The Right Honourable Prime Minister.
Mr. Speaker, no. Ministers need to follow the law, just in the same way that Labor ministers followed the recommendations that came from the Overseas Investment Office. If they want to change that, they have to come up with reasons why. And if in a period of time the Overseas Investment Office comes back with the new recommendation to accept the bid, and let's argue for the moment that ministers then accept that recommendation, that will be the correct interpretation of the law unless they can come up with another reason, and if it's wrong, it'll have to be judicially reviewed.
Question number... Beg your pardon, supplementary question, Dr Russell Norman.
Thank you, Mr Speaker. Does he accept that his ministers will now have to apply the law as interpreted by the New Zealand judiciary, and that interpretation means they must look at the benefits that New Zealand buyers of this land could bring to New Zealand and compare the benefits that New Zealand buyers can bring with the overseas investors? And that has to be the test that they apply to give New Zealanders a fair go.
The Right Honourable Prime Minister.
Mr Speaker, that's exactly the point. The point is that ministers apply the law as it's understood. The previous understanding, as was developed through the courts, was exactly the one that the Overseas Investment Office applied. We now have new jurisprudence, and you're quite right, that both the Overseas Investment Office and the ministers will now have to consider this ruling, unless the Crown wanted to appeal the decision, which I understand is extremely unlikely, in which case, yes, they will have to go and consider the new benefits test as described and prescribed by the courts this afternoon.
Supplementary question, the Right Honourable Winston Peters.
How can the Prime Minister have confidence in two ministers who, at the first hurdle, where they're required to make a decision on the law, clearly, as the court has so kindly pointed out to them, were incapable of understanding the law? How can he have confidence in those two ministers now?
The Right Honourable Prime Minister.
Well, Mr Speaker, the member's just completely and factually incorrect. The interpretation of the Overseas Investment Act is one prescribed by the Overseas Investment Office. It's not for ministers to rewrite the law's interpretation by the Overseas Investment Office.
Question. Point of order, Leader of the Opposition.
Mr Speaker, I seek leave to table the document, the decision by Justice Miller setting aside the Crayford Farms decision dated today.
Leave is sought to table that document. Is there any objection? There's no objection. Question number 2, Todd McLeod.
Thank you, Mr Speaker.